there. So next up, we have Professor Douglas Harris from UBC Peter A. Allard School of Law, and he's going to go show you about condominium, a transformative innovation in property and local government. Let me bring in Doug. Hello, Doug.
Hello, Ryan.
How are you today?
I'm very well, thank you.
We're excited to have you here. I know before the conference, there were quite a few people that actually submitted your name, and that's why we reached out to you. And we're really excited to just have you here. And I'll let you kind of introduce yourself and get into your presentation. Okay.
Okay. Thank you for the. Thank you for that. And hello, everybody. Thank you for spending a few minutes with me today. I'm going to offer something quite different than what Wendy has just provided. Really helpful detail in the nuts and bolts of managing and running a strata property. My plan is to step back a little bit and to provide some of the context and both contemporary, historical, and a little bit of the global context for this form of ownership and of local government. Condominium is relatively new. It's only been around just over half a century, and in that time, it's very quickly become not just a sideshow, but one of the dominant forms of property ownership and also increasingly of local government. And so I just would like to talk a little bit about that and to tell you how I come at this. I teach property law at the Allard School of Law at UBC. So we're in Vancouver, and I started teaching in 2001. I wanted to teach a property law course that was connected to the city that I lived and worked in, and that my students, most of whom would live and work in, and look out on the city of Vancouver. And even in 2001, increasingly the dominant form, the dominant legal architecture was becoming that of condominium. And I'll show a few slides. These will be very familiar to many of you. Vancouver House, one of the Starchitect designed iconic buildings in Vancouver. When one looks at the skyline of Vancouver, increasingly it's a skyline that is dominated not by the commercial office tower, but by the residential condominium tower. And this is a relatively new development. Here's the tallest tower in British Columbia. I think it may be soon passed, if not already, by one in Burnaby, the Shangri-La Tower. Here it is looming over the downtown core, and from the angle of the photograph over the local mountains. Many of you will know this tower. It's a mixed-use development with a hotel in the lower 15 floors and residential condominium units in the upper floors. To its right, the Macmillan Bloedel building and one of the Bentall centers. Interesting illustration of this shift in the skyline and the appearance of Vancouver from one that was dominated by office towers to one that is increasingly dominated by condominium towers, and you can see them running down with Cole Harbour in the background towards Stanley Park. A few decades earlier, these towers would have been, many of them, if they were residential, would have been residential tenancy rental buildings, now almost exclusively condominium buildings. This is true not just in the city core, but here out in Burnaby with Central Park just to the left, Metrotown in the foreground, Brentwood in the background, these rising clusters of condominium developments. So this was the landscape that I was trying, at least in part, to explain to my students and to help them understand this form of ownership, that would become, for many of them, if they were fortunate enough to own land in the Lower Mainland, they would be owning land less and less in the single house lot and more as a strata lot in in an apartment tower or townhouse complex would also be a legal form that they were encountering in their practice as lawyers. Vancouver is extraordinary in the extent to which its residents now live within condominium, either as owners or as tenants from owners within condominium. We have the highest proportion of people living with condominium of any city in North America. But this isn't only a Vancouver story. This is the skyline of New York, looking across Central Park in the foreground. A skyline that was again once dominated by the Empire State Building, the Pan Am Building, the MetLife Building, other commercial office buildings, increasingly dominated in recent years by the condominium form. Condominium really is spreading and becoming the dominant form of land ownership in cities across North America, and not just in North America. This is wrong side. This is the tallest building in the world, the Burj Khalifa in Dubai. It's a mixed use with retail and commercial on the bottom floors, hotel, and then residential apartments. The tallest building in the world now is primarily a condominium building. So another way of thinking about it is that with all this glass and steel and concrete and structural architecture, the legal architecture of these buildings is the condominium form, a legal architecture that allows for, as I'm sure all of you know, the capacity to be the owner of an individual unit. As an owner of an individual unit, you own a share with all of the other owners of the common property, and together you have voting rights in a strata corporation or condominium corporation or association of owners with the capacity to make and enforce rules that govern the use of the common property and also the use of the individual lots. And if we look elsewhere in the world, this is a development on the outskirts of Shanghai. The scale of development in China dwarfs anything that's happening certainly in Vancouver or Canada or even North America. This is Evergrande's Life in Venice development. Evergrande is, as I suspect many of you heard, one of the developers that's in serious financial difficulty in China. This Life in Venice, I think, is a nod to those canals that you can see between the rows of apartment towers. In China, there's no equivalent for individuals of fee simple or freehold ownership, but there are long-term leasehold interests, 40 years, 60 years, and so to the extent that there is market housing where people can buy and sell units in the marketplace, those units are created within the condominium form. Condominium has become the form in which those who own land are owning land. And one last example. This is from Addis Ababa in Ethiopia. As in much of the developing world, there's this massive transition of people from rural lives to urban lives. This is true not only in the developing world, it's true globally. And somewhere in the early 2000s, more than half of humanity now lives in cities. We've become an urban species. In Addis Ababa and other parts of the developing world where this is happening rapidly, now there's a huge housing shortage. And in Ethiopia, the central government has used the condominium form. So it's built these 4 and 5 and 6 story apartment units sold them at subsidized rates to individuals or families coming in to the cities, and is using the condominium form, so they become owners now in a unit that after a number of years can be bought and sold on the market. So condominium has become the form that governments and developers around the world are using in order to provide housing. One last image of this, of one of the hundreds of thousands of units that have been created in Addis Ababa in Ethiopia. This is a long way from the luxury pencil-thin towers that are now increasingly dominating the New York skyline, or even the Shangri-La or Metrotown or Brentwood in British Columbia. But it is revealing of the extent to which governments around the world, through legislation, have chosen the condominium form as the form in which people will find housing. Now, how did we get here? How did we get to a situation where there are now millions of condominium developments around the world, creating tens of millions of unit, housing hundreds of millions of people, and everywhere this is expanding and growing? How did we get to this point? Well, in North America, the story begins with the change in the National Housing Act in the United States. This small change in the National Housing Act in 1961 allowed for the federal mortgage insurance to extend from single lot or single family developments in single lot houses to one family units in multi-unit structures. Right? The mortgage insurance that the National Housing Act provided to lenders now extended to lenders who were taking one family units in multi-unit structures, taking condominium or strata lots as security for a loan. And this precipitated across the United States the development in individual states of statutory condominium forms. And the same thing happened in Canada, and British Columbia was the first province in Canada to pass a form of statutory condominium or to create condominium legislation. We did so in 1966, borrowing a template from New South Wales. In 1966, we passed the Strata Titles Act, and in doing so, became the first province to introduce the statutory condominium form, and all of the other provinces in Canada followed in the coming years. And so by the early 1970s, across Canada, the statutory condominium form was available everywhere. And here you can see I've underlined Section 3 of the first act in British Columbia, the Strata Titles Act. Land may be subdivided into strata lots by the deposit of a strata plan, and those lots act as interest in land. Right? They may be transferred, leased, mortgaged, or otherwise dealt with in the same manner and form as any land the title to which is registered. So with the deposit of a strata plan, one could create strata lots, and those strata lots were parcels of land that could be owned separately, registered separately, taxed separately. And so this form, which now increasingly dominates our property market in Vancouver, in British Columbia, appeared only in 1966, and the first use of it was actually not in the urban core. It was in Port Moody, and it was this development, Chateau Place, strata plan, New Westminster 1. This was the first strata plan deposited in 1968, and created this three-story mix of townhouse and apartment strata lots, and it was created with the deposit of this strata plan, like the strata plan, the constituting document that brings the strata lots and the strata corporation into existence. And there was a fair bit of excitement about the possibility that condominium or strata property created. And the very first text on condominium law in Canada by Alvin Rosenberg in 1969 created or attributed a great deal of power to this legal form, and it was seen to be a transformative possibility. So this is from that first text on condominium in Canada. In future years, condominium may well be instrumental in affecting major changes. Large parts of the urban population may be shifted to the city cores, where costs of servicing public facilities and transportation are at a minimum. It would pull people back into cities. Part of the impetus for condominium was to slow or to reverse urban flight. People were been leaving cities for the suburbs, and the possibility of ownership, where land was becoming increasingly valuable, would pull people back into cities. And it was thought that this possibility to be an owner would help create, as Rosenberg describes it, a new class of responsible citizens with a larger stake in the community because of their private ownership. And so attributing a good deal to the importance of private ownership and to its capacity, so Rosenberg thought, to build a sense of individual ownership of a unit, but also of an investment in a community. The trend towards tenant living may be reversed. So this is an interesting comment, a sense that somehow tenant living was less than or less desirable than private ownership. An interesting comment in the context of Vancouver, where residential tenancy buildings largely stopped being built in the 1970s, and only condominium buildings, towers were being built, and condominium, many of which were lived in by owner occupiers, but many also were owned by owner investors, and much of the new form of rental apartments was being built and produced within the condominium form. Rosenberg goes on, if the democratic capitalist society is to remain vital and vibrant, there is a need for the type of citizen who takes pride in owning his or their own home or business premises. You can feel the echoes of the Cold War in this. This was a market, an appropriately market-based response, a private property response to pressures for the need for housing, a market-based response in contrast to the response in the Soviet bloc, which was to produce social housing. So this was a market-based response. Condominium was that form that would allow for new housing, and so there was uptake after the first the Shadow Place in Port Moody, and then over the ensuing years, developers embraced the form. Lenders were prepared to take strata lots as security for a mortgage, and purchasers became increasingly comfortable. And here's a map from an article of mine a few years ago. The first 11 years of strata property development in Vancouver, each of those dots is an individual strata lot or individual strata development, and you can see the early density of units and kits, ranging from duplexes to 3 and 4 story walk-ups. Some of the towers that are appearing in the West End, Fairview Slopes, you can see some of the early developments there, even on the Vancouver city land in False Creek South. You can see some of their early developments. Now, one of the things that happened was it was not just new build developments in these early years, but also residential tenancy conversions. So this fellow has received a notice from his landlord informing him that he is now able to buy the unit that he's living in because it is being converted from a residential tenancy development into a strata property complex. And you can see the sign now selling luxury apartments. Doesn't look particularly luxurious, at least not by a 21st century standard. And then that less than rent. So the payments on your mortgage loan would be less than rent if your down payment were large enough. This produced protest in parts of the city, and here in Kitsilano in 1974, there's a protest over a conversion of that residential tenancy tower in the background there. It's being converted into a condominium or strata property development, and communities of tenants who could afford to live in these buildings as tenants are now being told they can buy, but many of them are not in a position to buy. And Kitsilano in the 1970s, a different place than Kitsilano in the 2100s now, or the 2023, a site of protest. And one of the developments that became a flashpoint, or one of the conversions that became a flashpoint for protest, was when Highcroft Towers was converted also in the early 1970s from a residential tenancy building to a condominium building. And this provoked the city of Vancouver to impose a moratorium. It was the first in North America, a moratorium on the conversion of developments from residential tenancy buildings to condominium buildings. A moratorium that lasted for much of the 1970s, and then was replaced by provisions that required landlords that were converting buildings from residential tenancy to condominium buildings to provide relocation funds and a certain number of months' rent to the former tenants. So also in the early 1970s, British Columbia became the first province in Vancouver to take a legal form that had been designed for the subdivision of buildings like this one, to create individual strata lots in buildings with the boundaries of the strata lots defined by the floors, walls, and ceilings, to take that legal form and extend it to the subdivision of rural or suburban land. And this is the largest, what became known as bare land strata subdivision in British Columbia. This is the Arbutus Ridge development on Vancouver Island, a little bit south of Duncan, north of Victoria, looking across to Salt Spring Island and to the Schwartz Bay ferry terminal. Here it is, the aerial image of it from Google Earth. I tell my students in property law that Google Earth may have all sorts of uses, military and otherwise, but I think it was designed primarily for property law professors who can show the spaces that they're talking about in the classroom. So this is the Arbutus Ridge development, the Google Earth image. You can see it wrapping around a golf course that was at one point part of the development. The development ran into some financial difficulties in the late 1980s and early 1990s, and the golf course was separated out. But it took the strata property form and used its bare land iteration to create a 646 strata lot subdivision. And here's the location, again, just south of Duncan, looking across to Salt Spring Island. And this is the strata plan that brought the Arbutus Ridge development into existence, or at least this is the strata plan in its 20th phase. This was a phase development built out over 2 decades and 20 phases, and it's the last phase that creates the last strata lots that bring it up to 646. And Arbutus Ridge, this is from the homepage, describes itself as a seaside community for active adults. It's a lifestyle community. It's a community that is marketed and targeted towards active adults. And the homepage references Sun City in Arizona as the template that these communities that were built and targeting a particular demographic. And let me pause here for a moment to say that I've focused on, to this point, the property interest that condominium creates. I mean, these individual lots and a share of the common property, those individual lots and a share of common property are embedded within a structure of private local government. And so, and that private local government with the capacity to create and enforce bylaws. And so it's those bylaws that allow for the construction of a particular type of community, and in this case, a community that limits the number of occupants in each unit, that limits what can be done with landscaping, with the form of the buildings, with what you can park in your driveways. It's also that form of government that enables the collection of strata fees and then their use for the provision of community amenities, in this case including games room and swimming pool and a dock, but also services, in this case a security guard and cameras at the gate. I've been doing some work on Bearland strata in the last few years, and here are a few maps of that work. There are, as of 2019, 2,600 Bearland strata developments in British Columbia, and you can see that inset map in the lower left. They're concentrated in the Okanagan, in the Fraser Valley, and on southeastern Vancouver Island. And the larger map shows southeastern Vancouver Island. Of those 2,600 Bearland strata developments that create almost 50,000 individual strata lots, almost half of them are on southern Vancouver Island, and many of them are in the municipalities around the city of Victoria itself. You can see the density in Langford and Colwood. And it doesn't show it on this map, but up the Saanich Peninsula. So again, just sort of by way of recap, condominium or strata property, and I've used those terms interchangeably. In British Columbia, we use the strata property form. In much of the world, it's known as condominium. Other places call it apartment ownership, or horizontal title, or sectional ownership, or unit title. But under those different labels, and in urban cores, and in many suburbs, and in spaces where rural land is becoming suburban, the condominium form, with its production of individual lots that can be owned within a structure of local government, is no longer the exception. It's becoming the norm. And now I'd like to focus for a little bit on this structure of local government. And it's a structure of local government that I've labeled private local government. And it's private in the sense that one's right to participate in the Strata Corporation is a function not of citizenship or of residence, but of ownership. One has a right to participate as an owner. It's a form of government by owners, not of residents, not of some combination of residency or citizenship, which is how we identify the right to vote in public governments, municipal, provincial, or federal. Rather, the right to vote, the capacity to participate in this form of private local government is defined by one's status as an owner. What's also interesting, though, is that many times that form of government is described as akin to or similar to municipal government. The AGM is commonly described as analogous to or similar to a town hall meeting. The annual general meeting or special general meeting is often described as similar to a town hall meeting. And Strata Property Governments, the Strata Corporation, is doing many of the same things that municipal governments do. Their municipal governments are concerned primarily with property interests and with servicing property interests. And that's what strata governments do. They're concerned primarily with a set of bylaws that regulate the use of the common property and of the private property, and then of collecting fees, form of tax that provides services and amenities to the residents in those units. And this form of property and ownership has enabled, particularly in the urban context, a new density of owners. It's been the case that humans have lived in close proximity in cities for decades, but until recently, we lived in towers as tenants, and now we have the capacity to live in towers as owners. And what the strata form enables is this massive increase in not so much the density of people, but the density of owners. So the idea of ownership emerged in a context where owners were spread out on a horizontal plane over the surface of the earth. And this is what bare land strata allows for the subdivision of land in a single horizontal plane. In a building context, it allows for subdivision within a building. And so now owners can be stacked in a vertical column, 40 or 60, 80 or 100 or more, as in the Burj Khalifa Tower, stories high. This is a massive increase in the density of owners. It's a reconfiguration of ownership. And one of the things that I've been interested in is how this density of owners, this new density of owners, is changing what it means to be an owner of an interest in land. And let me shift sort of from the geographical and historical context to look at some of the particular legal issues that arise in the condominium context that are a function of this new density of ownership. This is a townhouse development of 36 units in Toronto. For those of you that know Toronto, it's near Bay and Bloor Streets, just east of Bay Street, not far from Yorkville. And this development, Toronto Condominium Corporation, number 747, had an owner within it, Miss Korolek, who is what many would describe as a neighbor from hell. She was loud, she was abusive, she had a large dog which she would let run to the end of its tether and then stop it just as it was about to appear to jump on residents. She would climb into balconies and poison plants. She was threatening, she was abusive, and she had destroyed any sense of community. Her behaviors had destroyed any sense of community in this development. And eventually, after many orders that she stopped this behavior and many fines for violating the bylaws, which were ignored, the condominium sought an order from the Ontario Superior Court to evict Ms. Korolek and to force her to sell her unit. And the Superior Court in Ontario granted that order, that she be evicted and that she sell her unit. And this is what the judge in that case had to say, that in all of these circumstances, her violent, abusive, her threatening and destructive behavior, it would be unwise to try to reintegrate Ms. Korolek into a community that fears her and that she has persistently tried to intimidate. People join condominium corporations voluntarily on the basis that they agree to share collective property and abide by the rules. There's no right to continue membership in this corporation or this community once a clear intention to harm it and a persistent refusal to abide by its rules have been exhibited in the extreme ways in this case. Ms. Korolek has irreparably broken the bond with her community, and an effective order that cannot be made that would force these parties to now join together. And so the judge orders that she be evicted and that she sell her unit. And let me pause there for a moment to say just how extraordinary an order this is in the context of an owner, that on the basis of behavior, that she be evicted and forced to sell. If one thinks of a city block or a suburban subdivision with a neighbor exhibiting all of these threatening, destructive behaviors, a court would never provide an order that she be evicted and be forced to sell. There may be an action for wrongdoing and tort. The police would be called. There may even be criminal punishment, but there would never be an order, an eviction and forced sale order. But there are now a number of cases in Ontario and also in British Columbia where courts have been prepared to make such an eviction and forced sale order in a context of chronic and extreme antisocial behavior. And the first reported example in the case law that I've come across is this one involving a mother and son, Rose and Geordie Jordison, who owned, Ms. Jordison owned a strata lot in this complex in Surrey. They had a very volatile relationship. They were frequently loud and argumentative. They would host loud parties. Geordie Jordison was could be threatening and intimidating. There was garbage that piled up in the common areas outside their units. But the behavior continued over 4 years. There were $20,000 in fines. None of this was having any effect on the behavior. In this case, the Strata Corporation sought an order that the Jordisons be evicted and that Ms. Jordison be forced to sell the unit. And the BC Supreme Court granted that order in 2012. The Jordisons appealed, and the BC Court of Appeal overturned that order, and on the grounds that there needed to be a first order that the behavior cease, and that if the Jordisons were in contempt of that first order, then perhaps the order for eviction and forced sale might be appropriate, but not as a first order. So the BC Court of Appeal threw out the order for eviction and and sale, but upheld the order that they stop behaving as they were. The behavior continued. The Strata Corporation went back to the BC Supreme Court for an order that they be evicted and that Mr. Jordison be forced to sell, and the BC Supreme Court granted that order. And this time, the BC Court of Appeal upheld that order in this decision. Oh no, I beg your pardon. In this decision, and in doing so, the court said the behavior was not as severe as in the Coralec, as in Ms. Coralec's case, but it nonetheless warranted the order that the Strata Corporation sought. And here the court says, paragraph 25, the competing private property interest, which supports a strict interpretation of the act and of the power that it gives the court to order eviction and forced sale. That strict interpretation must, in the court's opinion, yield to the rights and duties of the collective as embodied in the bylaws and enforceable by court order. The old adage that a man's or a person's home is their castle is subordinated by the exigencies of modern living in a condominium setting. Right? That this condominium setting where there was a proximity or a density of owners that was new warranted a transformation in what it meant to be an owner, that as an owner you were now subject to a minimum threshold of behavior in order to maintain your status as owner. At some point, your rights of ownership could be lost if you failed to live up to your responsibilities as an owner to be a part of a community. Now, when I looked at these cases, my initial thought was that these orders were appropriate, that ownership was about rights, but also responsibilities. I found buried in most of them a reference, and in most of them it was passing to mental illness. And there's a reference to Geordie Jordison's mental illness, and there was the beginning of a human rights complaint that didn't proceed, but the basis of that complaint would have been that Geordie suffered from a mental disability that made it, that predisposed him to make it difficult to live in close proximity with others, and that such an order to evict and sell their unit would be discrimination on the basis of disability. And in most cases, that analysis around whether there's a human rights claim isn't developed. But it is in this case, another Ontario case involving JMV, a woman who suffered from severe mental illness, who was in and out of hospital for that mental illness, sometimes involuntarily committed to that hospital. Her behavior wasn't violent or threatening or intimidating. She was a hoarder. And the apartment filled up with stuff. And as a result, there was water damage and the danger of fire and pests. And she would be removed and involuntarily committed. The Strata Condominium Corporation would clean up the apartment. There would be garbage trucks load of stuff removed. She would come back, would be stable for some months. The behavior would then resume, and eventually the court said that the Strata Corporation or the Condominium Corporation had accommodated her mental illness under the Ontario Human Rights Code to the point of undue hardship, that it was required to accommodate her mental illness, and not to do so was discrimination on the basis of disability. But that accommodation only had to go so far as undue hardship, and that point had been reached. And so in this case, the court ordered her eviction and the sale of her unit. And now let me bring this to a close with this observation, that I think these issues in this one example of mental illness and the challenges that the proximity of ownership creates, and of mental illness in this density of ownership creates, is something that strata corporations are going to need to grapple with, and attention is going to need to be paid to the Human Rights Code and to the human rights regime and to the duty of strata corporations to accommodate not just mental illness but many forms of disability, but accommodate to the point of undue hardship. And I think this series of cases reveals some of the particular challenges that this form of ownership, which is still relatively new, it's only been around not quite 60 years in British Columbia, but in those 60 years has become not the exception, but the norm for owners. These cases reveal some of the challenges that the structure of private local government that condominium creates are going to face going forward. So let me close there. I think there's a few minutes for questions. I'd be very happy to answer any. Before I go, we at
Yes.
UBC with the University of New South Wales are hosting a workshop in May on multi-owner properties, and you can find a link if people are interested. There's possibilities to attend in person or online, and you'll find a link through the Law and Cities Research Group at the law school. So, Ryan, with that, let me stop and turn things over to questions.
Awesome. Yeah, that was a great presentation. I posted the questions in the right-hand side there, so you can start to see what they are.
Kathy, I believe the first strata was in BC in Port Hardy. There was an early strata corporation, strata development in Port Hardy. I'm not in. I think it may have been surveyed first, but registered second. But I will go and check. And I think it was in a company in as part of the pulp mill there, or a development. Anyway, I'll have a look at it. Thanks for the tip. Thomas, can you describe how airspace parcels compare to traditional strata structures? Are we likely to see more in the future? So developers now have a choice when developing a building or developing a complex that has multiple uses. So one can. Right, there are now many examples where there's retail at one level. There may be professional offices at floors 2 through 4. There may be a hotel at floors 6 through 10, and then residential strata lots in floors 11 through 20. And so these very different uses create different demands on the common property. How do you separate out the expenses? And one way to do that is with sections, separate sections within a strata corporation. Another way to do it that creates more separation is with airspace parcels. So you first, the developer would deposit an airspace plan that creates separate parcels of land defined in 3 dimensions. And there are now some developments that have 3 or 4 or 5 airspace parcels. And then you can build a building, and different parts of the building may be occupied by separate airspace parcels. And those airspace parcels can themselves be subdivided with the deposit of a strata plan that creates individual strata lots. So there's different techniques for using these tools to subdivide land in ways that create more or less separation. And I think increasingly developers are using airspace parcels first, and then subdividing some of those airspace parcels with strata lots rather than using sections within a strata corporation. So yes, with these multi-unit developments or multi-use developments, I think we are likely to see more. The question 4, is it accurate the bank and financial sectors are the origin of this type of property, and then secondarily, an individual who individually owned the land, not the actual buyers of strata lots. So I think, I mean, the success of this legal form, and by success, I mean its proliferation. It is one of the most successful innovations in property, simply by virtue of its proliferation. I think the numbers are that half of the residents in Vancouver now live within condominium, either as owners or as tenants. I'm not quite sure that it's quite that high, but so it's enormously successful measured by its proliferation. And that success has required that it be a form that developers want to build, that purchasers want to buy, and that lenders are prepared to take as security interests for loans. Right? So lenders need to be prepared to take a mortgage in a strata lot as a security interest for a loan. So the success of the format is a function of builders wanting to build, purchasers wanting to buy, and financiers prepared to finance. And there's a whole set of incentives that have contributed to excess in the tax system. So I think banks and the financial sector are an important part of this. And another part of the success, I mean, money has been pouring into cities. It's pouring into cities primarily to build strata property units or condominium developments. And so condominium has become a financial asset. And for many people who can invest in land, they can do so at the level of an apartment, not at the level of a freestanding parcel of land. And so it's become a vehicle that's drawn money into cities. Fifth question: the legal architecture seems incredibly complex, yet it claimed to be a consumer protection law. So this is interesting. In Australia, many of the responsibility for strata property is housed within ministries of consumer protection, and so part of the early impetus for strata property was to create templates. Right? So if you were to buy an ownership interest in an apartment, there would be one template, the strata property template. That would be the template that you would use, rather than creating a whole set of individual forms. So it was sort of the simplicity, the off-the-rack nature of condominium ownership or of the strata property unit that was intended as a form of consumer protection. I think it's a real question with now the complexity, particularly in these developments that are multi-use with airspace parcels where and condominium developments within those airspace parcels, and those condominium developments share expenses with other airspace parcels, and those expenses are allocated in complex easement agreements to understand exactly what you as an individual lot owner are responsible for. What's your share of the parking maintenance expenses? What's your share of the common amenities? It's now increasingly difficult to figure out with all of this complexity. And so I think we're in danger of creating such complexity that it's hard for the individual owner to understand exactly what it is they're buying. And I think that's going to be an important issue for us to look at.
Yes.
Ryan, how are we doing for time? Are we done?
Yeah, we're just wrapping up there. Looks like we have 30 seconds left. So we made it quite to the end. We have a few other questions, but we will reserve those for being answered later. So we'll make sure to touch base with you again, Doug. Thank you so much for your time and your presentation. I learned a few new things as well. And I'm always happy to have you on, and we really appreciate it.
Thank you, Ryan. Enjoy the rest of the workshop.
Thanks. So next up, we have Ryan Stenquist with Condo Clear Services, and he's going to cover what are your strata documents saying?